Welcome to today's program titled Protecting Trade Secrets in Government Contracting, Risks and Safeguarding Strategies, the ninth session of our Winning Combinations webinar series. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation by using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email that you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to today's presenters. Ken and Robert, you may begin.
Thanks, Sadie. Good afternoon, everyone. Welcome to today's Winning Combinations webinar. I'm Ken Kinzella, counsel in Seyfarth's government contracts practice. I help clients with bid protests and contract disputes, teaming agreements, subcontracts, NDAs, as well as small business issues. I also help clients with grants and other agreements, M&A, due diligence, and suspension and debarment matters. Robert?
Hi, everybody. Thank you for joining us. My name is Robert Trezzoli. I'm an associate in the intellectual property group at Seyfarth Shaw. I help clients protect trade secrets, help with trademark acquisition and enforcement, and intellectual property transactions, more or less all things intellectual property. I also advise in healthcare counseling and disputes, general litigation, and non-compete disputes.
So the purpose of today's webinar is to cover considerations for government contractors in protecting trade secrets from the government, competitors, team members, and the general public. And we'll cover four major areas. First, what are trade secrets? Second, what laws and mechanisms protect trade secrets? Third, how does government contracting pose unique risks to government contractors? And fourth, and finally, best practices for safeguarding trade secrets. I'll turn it over to Robert to kick off our discussion. The first question, what are trade secrets?
Thanks, Ken. Trade secrets, simply information that's not generally known to the public, that the owner has taken reasonable steps to protect, and that derive independent economic value from not being generally known. We'll touch on several statutes and other protections relating to trade secrets today. However, I'm going to start off with the primary, trade secret statute in the U.S., which is the Defend Trade Secrets Act, which was enacted in 2016. States have enacted their own versions of statutes protecting trade secrets. These all generally align with the DTSA, or the Defend Trade Secrets Act. And so the Defend Trade Secrets Act has a definition of trade secret, and in that regard, it defines information that can be subject of a trade secret quite broadly. It specifically identifies the following categories: financial information, business information, scientific information, technical information, economic information, and engineering information. For example, trade secret can be customer lists, pricing information, source code, processes, procedures, schematics. It's a very broad scope of information that can constitute a trade secret. To be a trade secret, the information needs to be not generally known to the public. That's pretty explicit in the requirement that a trade secret is, in fact, secret. A key factor here is that the owner has to take reasonable measures to keep information secret. Very important here is that reasonable is not a one-size-fits-all term. There's no specific checklist that a company needs to meet. Reasonable can depend on a variety of factors. Some of these include, let's say, the size of the organization, the value or importance of the trade secret itself, who needs to know the information to perform their job duties. For example, the reasonableness of protecting a company's secret sauce, recipe, or source code can be treated differently than how they protect, let's say, pricing or customer lists. Some common ways to ensure protection of trade secrets and are kind of considered in the reasonableness analysis include proper contractual agreements for people that come into contact with trade secrets. This would include, for example, non-disclosure agreements. And then, as you can imagine, likely everybody here works on a computer, password protecting your computer and storage locations, limiting information on a need-to-know basis, and, limiting what employees can access which information. For example, HR may not need to know what the schematics or the source code is that, the company runs. Another element that's going to play a big part today is marking. From a business perspective and just in general, you can mark documents, presentations, even emails and everything else. You can mark those, confidential, highly confidential, however you determine and decide to mark things within your business plan. A big point is to have internal policies, but also follow those internal policies. If you've identified what is reasonable through a policy and don't follow it, then it's a tough argument to say that you've been acting reasonably. And last thing I'll touch on is enforcement. You want to make sure that, if you come across a bad actor, let's say that has stolen a trade secret, or even somebody that may have accidentally disclosed something, you want to make sure that you silo that information, shut down the sharing of it, and get it back. The last element is that the information derives independent economic value from not being generally known. And you can think of this, for example, pricing list. Competitors can use a pricing list to undercut your business. And in that regard, there's value in keeping that pricing list secret, similar with the source code or other trade secrets. A key factor that makes trade secrets valuable are the fact that they can last in perpetuity. They can last forever so long as they meet the specific requirements that I just mentioned. For example, a recipe for, let's say, a cola can last forever, or source code for a search engine can last forever so long as the information's kept secret. Trade secrets stand apart from other IP rights in that regard. In general, for example, patents. Patents, part of the trade-off that you get when you obtain patent rights and the right to exclude others from using that is a 20-year exclusivity. So, for example, you may consider patenting, let's say, a physical product that you're going to put in the market versus keeping trade secrets because individuals can reverse engineer what you put in the market, and that wouldn't necessarily be a violation of trade secret protections. As I mentioned, there's various statutes that and other protections that flow and protect trade secrets. The DTSA, again, is the primary federal statute protecting trade secret laws. There's also state laws that protect trade secrets. I'll note these state laws can be particularly important when you're, contracting with state or local governments and or, your contracts with subcontractors or other third parties. There's the Trade Secrets Act, which prohibits the government from disclosing private parties' trade secrets. And I'll note briefly that there is an exemption to FOIA requests that would hopefully stop the disclosure of trade secret information, but it is not foolproof. With that, I'm going to pass it on to Ken.
Thanks, Robert. So from the government contracts specific side of things, there's some additional laws and protections that are relevant to trade secrets. So in addition to Trade Secrets Act and FOIA, there's the Procurement Integrity Act, which prevents government employees from knowingly disclosing contractor bid or proposal information or source selection information. There are criminal and civil penalties for that. Next, I want to talk about markings. So Robert talked about marking generally, but when it comes to the FAR and DFARs, there are specific markings that you are prescribed for different types of data to ensure that the government does not use it beyond the scope of the license you're granting it. So these rules are really important. It's really critical to mark your data properly. If you don't, you can lose control of how the government uses your data or to whom it discloses that data to. So just as background for this, I'm going to cover briefly the different categories of rights and markings that there are. So there's unlimited rights. which the government gets in data first produced under the contract or data delivered under the contract. And the government gets a license to use that for any purpose whatsoever. It can use your data, modify, reproduce it, display it, so on and so forth, or can have or authorize others to do so. On the other side of the spectrum, there's limited rights. And so that's in data that's developed at private expense, something I'll cover in detail later. When it comes to limited rights data, the government can use your data within the government, needs your permission to disclose outside the government, with some exceptions for emergency repair or overhaul. There's similar to limited rights, there's restricted rights in other than commercial computer software. There's also SBIR, STTR data rights, essentially another version of limited rights. Lasts for 20 years though, so it's really a unique benefit that attaches to SBIR and SCTR awards. In between the scope of what I talked of unlimited rights and limited rights, there's other rights allocations. There's government purpose rights when it comes to dealing with the DoD when there's mixed funding involved. One of the major themes here is when it comes to what rights the government gets is it generally turns on who paid for the data. So if the government is paying for the data, generally gets unlimited rights. If it's the contractor who's paid for the data, the contractor can assert limited rights. And then these government purpose rights and especially negotiated license rights, it's another form of rights that kind of exist for data that's developed at mixed funding expense. There's some other types of data rights categories. I'll just list them. There's special commercial computer software licenses are a little different. The key here is you want to be aware of these various rights regimes, what rights you are granting to the government when you agree to provide something at under one category versus another. And it's important to know which marking to use because the FAR has specific markings that you are supposed to use and a challenge procedure if you use incorrect markings. Next, I want to cover enforcement mechanisms. There's a variety of enforcement actions you can pursue if the government misappropriates your trade secrets. There's various considerations as far as which one you might want to use. Turns on, what's the nature of the relief you're seeking? Are you looking for damages? Are you looking for an injunction? Some of these enforcement mechanisms, only one might be available and not the other. You got to consider where is their subject matter jurisdiction. Certain courts have an authority to hear claims that are based in contract, others in tort. Really depends. Are you the prime or the sub, right? Another consideration. If you don't have privity of contract with the government and the government's misappropriating your information, you need to consider how you get your case heard. There's a variety of ways to do that, but such as, if it's a contract claim, you may convince your prime contractor to sponsor a breach of contract claim against the government. If you can't do that, you might have to resort to a Fifth Amendment takings claim or somehow allege third-party beneficiary status. But these are all important things to consider. No single right answer, of course, all depends on the particular facts, whether you can meet the applicable burdens of proof. Definitely want to consult with counsel, but here are some of the potential mechanisms you can use. First, I want to cover breach of contract actions. Under these actions, under Contract Disputes Act, you can get declaratory relief, monetary damages, but the boards and the Court of Federal Claims cannot issue injunctive relief under the Contract Disputes Act. In turn, when it comes to subcontracts, injunctive relief might be possible if monetary damages are inadequate. These are cases that wouldn't be brought at the board or Court of Federal Claims, but more likely to be in state or federal district court. Other actions that you can pursue to enforce your rights here are you can file a bid protest for violations of the Procurement Integrity Act. There's specific timelines you need to be aware of. You have to report a violation to the contracting officer within 14 days of when you knew or should have known of a violation of the Procurement Integrity Act. And then thereafter, the government conducts an investigation. Once that concludes, you need to file a protest within 10 days. So it's a pretty compressed timeline. Under bid protests that allege Procurement Integrity Act violations, you can't get compensatory damages, but you can get a contract canceled, you can get an offer or disqualified, or a competitor's contract voided, things like that. Through the bid protest process, you might also be able to allege that a competitor who obtains your sensitive information improperly has an organizational conflict of interest. Other types of actions you can bring include, it's rare, but in theory you might be able to bring a Federal Tort Claims Act suit in district court. That would be governed by state law. You might be able to bring a Fifth Amendment takings claim, which I mentioned earlier, under a Supreme Court case called Ruckelshaus versus Monsanto. Trade secrets can constitute property subject to the takings clause. If you bring this type of suit, you might be able to obtain damages, but generally not an injunction. The last type of action I want to cover here is an action under the Administrative Procedure Act, under which you may be able to obtain injunctive relief against the government, but no monetary damages. This can be a high hurdle because the standard here is whether the government acted arbitrarily, capriciously. So kind of a high bar. I'm going to turn it over now to Robert to kick off a discussion on risks to trade secrets posed by government contracting.
Okay. So there's various risks that, come to trade secrets, and they can come in many forms. So I'll speak generally to them. Of course, there's always going to be bad actors, individuals or entities that are, attempting to, let's say, break through your security, phishing scams, things of that nature to obtain your trade secrets. So you always want to have protections in that regard. So other ways that, could be dangerous is bad contract language, failure to properly protect trade secrets through non-disclosure agreements, perhaps exchanging information beyond what is covered by an agreement, failure to define the ownership of trade secrets or information that is newly formed. Some other ways are employee departures. Employees with knowledge of the company's trade secrets can move to a competitor. So there needs to be proper contractual language in that regard that protects the trade secrets and doesn't run afoul of other statutes or limitations, for example, non-competes, which several states do not necessarily allow for various classes of employees. There's also instances of accidental disclosure. Perhaps an employee is giving a speech at a conference, displaying some new product, and discloses some trade secret information. Again, that could be pricing, that could be where the company is gearing up to proceed in the future. There's also instances, and I've seen this, where somebody posts a photo, of an event at, let's say, an office. Maybe it's a birthday party or it's something similar, and in the background there's some trade secret information or potentially trade secret information. And that's posted on social media. So now it's become public, and the trade secret, if that information did constitute trade secret, could be lost. As I mentioned earlier, trade secrets are required to maintain trade secret protection. Are required to take reasonable efforts. Failure to take those reasonable efforts could result in loss of the trade secrets. Again, failure to follow internal policies. Failure to properly mark information, or failure to respond to contractual obligations or requests, are all instances that failing to take reasonable efforts. For example, most contracts require a notice period, or at least a notice that a party is going to disclose confidential or trade secret information, whether that be as part of another investigation or lawsuit. It's imperative that you maintain, proper procedures to file the necessary documentation, whether that's in court or otherwise, or just respond and say that you cannot disclose this information, because failing to do so, can result in disclosure and loss of the trade secret. I'll bring it up again. FOIA requests, the exemption that I mentioned earlier, it requires action on behalf of the trade secret owner. And so, when you receive a notice that a FOIA request has come through, you want to make sure that you're being responsive and guidelines that are necessary to seek the exemption. With that, I'm going to pass it on to Ken to get more in depth with government contracts.
Thanks, Robert. So let's talk about how government contracting steps and processes introduce unique risks to your trade secrets. In this regard, you want to think about all your touch points with the government and with external parties, and you want to make sure that you're protected or considering the risks that are posed by each of these interactions. So, of course, you've got proposals. You've got proposals you're submitting to the government or sharing with a team member. You've got contract deliverables. As we mentioned earlier, markings throughout any of these interactions are going to be really important. You've got other communications like emails. Keep in mind that if you're emailing the government, they may not be fully attuned to the level of sensitivity of information that you're sharing. So you really need to clearly indicate that if you think that certain information is a trade secret or otherwise sensitive, you need to clearly mark that as such. There's the mandatory disclosure process. So under the mandatory disclosure rule, contractors are required to make mandatory disclosures to the government when they have credible evidence of certain wrongdoing. And you want to make sure that you're using your FOIA markings here. As Robert mentioned, FOIA requests, these can come in from competitors. They can come in from news media, oversight or advocacy organizations. And just to really reemphasize what Robert said, it's really important to stay on top of the submitter's notice process. So in addition to marking things on the front end, if a FOIA request comes in seeking your contract deliverables, seeking your contract, seeking things like that, you may end up having a very short amount of time to respond to that and identify what you consider a trade secret or confidential commercial information. So it's really important to stay on top of that process, and if needed, see if you can ask for a time extension. Another touch point is potential M&A activity where you're sharing information with a prospective buyer or litigation. This is another area where information that you treat as a trade secret is at risk of disclosure. And so, if you've got, say, for example, a contract dispute that you're pursuing at the Board of Contract Appeals, you may need to seek a protective order to make sure that your information is protected there. Another point I want to mention is subcontract and teaming agreements. A common thread we hear in this area is, a client will come to us and say, "Oh, we've got an NDA, it's covered." Well, you really want to make sure it is in fact covered. What is the NDA for? Does it cover the present subject matter? Is it still valid? One of the common scenarios we see is, a prime and a sub may have executed an NDA at one time that's scoped for a predecessor contract effort, and then they want to team up and go after the follow-on. One thing you want to look at is what is the scope of your NDA? Is that existing NDA adequate? Is it too narrowly defined? Is it broad enough to cover the current subject matter? And if it's not, you may need to execute a new one. Or another thing to consider is whether your non-disclosure obligations are, if they're in a teaming agreement. If they are, you probably want to have a separate NDA because teaming agreements commonly terminate once a subcontractor or contract is awarded, although there may be continuing obligations. This is just something that's important to think about. Another thing to consider is whether your subcontract has requisite flow downs to cover lower tier subcontractors. So if you're sharing information downstream, you want to make sure that you're including in your subcontracts the requirement to execute NDAs and implement appropriate protective measures. So I'm going to turn it back to Robert to discuss some best practices.
Okay. So we've kind of talked about how to protect trade secrets throughout this, and so I'm going to kind of recap some of the best practices. And one of the big ones is, every company should, as a best practice, have policies and procedures, protect and train others on how to protect trade secrets. For example, any employee that comes into contact with confidential or, let's say, trade secret information should execute a form of non-disclosure or confidentiality agreement, likely within the employee agreement. That should be all of these agreements should be signed prior to disclosure or sharing of any trade secret information. All employees should participate in trade secret protection training, how the company protects its trade secrets, its policies and procedures. The employees should take part, and they should also acknowledge that they participated in the training and that they agree to abide by the training. The training shouldn't be one time. It's best if there's periodic training, for example, annual training, whether that be virtual or not, and have the employee re-acknowledge their obligations there. It's also good to audit the policies, make sure what you're doing is working, things aren't slipping through, things that individuals are taken off of access to information they don't need or no longer need, and just make sure individuals don't have access to information that they don't need to know. Ensure that, again, as we've talked about throughout, and Ken just mentioned, that you have proper coverage in your contracts. Don't share beyond the information you've agreed to, and so on. And a big one is to really track the contractual obligations and be diligent. Again, if there's a notice procedure or something similar, you want to make sure that when that notice comes in, you are able to act quickly and protect your trade secrets. And kick it, close it up.
Thanks, Robert. So some additional things to consider. I mentioned earlier, government contract rights and data often turn on who paid for what. So to make sure that you're protecting your information adequately, you really need to have detailed record keeping, which can include charge codes for different projects. This is really important when you have employees working on multiple projects in the same time frame. You want to have clear documentation of project scope and policies to ensure that employees are accurately reporting which effort their work is associated with. In a related vein, you want to be able to mark at the lowest segregable level, who's paying for what. If this is developed purely a contractor expense, you really want to be able to identify that at the lowest segregable level, and that really is to ensure that you protect that information and preserve the economic value. When it comes to proposals, I know we're running out of time here. A few more items. Proposals, you want to identify and mark all technical data that are going to be furnished with less than unlimited rights. So you really want to pay attention to the data rights assertion table. When it comes to markings, you want to mark clearly and consistently. Use the right markings. So if you've got limited rights data that you're delivering, make sure you use the actual language from the limited rights legend. If not marked, it's going to be presumed that the government gets unlimited rights. And in this vein, you also want to familiarize yourself with the challenge procedure for overmarkings or incorrect markings, which the government can initiate if they think that you're marking things improperly. The reason why you want to familiarize yourself ahead of time is so that you aren't learning about the procedure for the first time when you're in the midst of a data rights challenge. And lastly, in addition to the FAR and DFARS markings, sometimes you keep in mind that you're delivering data both up the tier to a higher tier contractor as well as to the government. So sometimes you need to have multiple markings possibly on a deliverable, one that protects against disclosure by the government and one that protects against disclosure by that higher tier party, whoever that may be. So it looks like we're about to wrap up here on time. So I want to read, for those who are seeking CLE, There's an attendance verification code here, and that is SS0004. It looks like there's also a link here to scan to verify CLE attendance. Another thing I want to highlight before we sign off here is this webinar will be posted along with other items on the Seyfarth Claims and Sustains Government Contracts blog that's created recently this year. It's got a platform with several episodes so far that will continue to be uploaded, covering various topics in government contracts, timely insights, practical analysis. And with that, I want to thank everyone for attending. For more information, if you have any questions, feel free to reach out. Our contact information is on the screen. Thanks so much.
Thank you, everybody.